You've been watching reporting from within the Fulton County Courthouse of the hearing to be held regarding contempt, potentially, against the Fulton County Commission for failing to comply with the previous judge's order that they appoint two Republican nominees for the Fulton County Election Board, Jason Frazier and Julie Adams. Both of whom were duly nominated and submitted by the Republican Party of Fulton County, and yet the County Commission has steadfastly refused to do their part and complete appointment of those people to the election board. In their arguments, the plaintiffs focused on the fact that the court had considered previous arguments and had said that the word "shall" in this case means that the county commission must complete its duty to appoint Julie Adams and Jason Frazier to the election board. They noted that the court had given ample warning in its last order that the commissioners would be potentially in contempt of court were they not to complete this. They also cited the fact that existing law, both in Fulton County and in the state of Georgia, supports that a court order must be complied with or can subject those in violation to contempt. Finally, they cited a number of different social media posts wherein various individuals on the Fulton County Commission actually posted the fact that they would not comply regardless of the penalties which might be imposed, and essentially denying the court's ability to compel their behavior. The defense cited a number of things, specifically calling out the fact that the commissioners have only one tool to use, which is their vote, and that they must be able to vote their conscience. They further suggested that a court may not compel individuals to act in a given way. The plaintiff came back and called that strongly into question. And most people will realize that court orders often, in many cases, not just this one, compel individual behavior and individual actions such that the individual can comply with the court's order. The court is now in recess, and the judge is now moving to consider the arguments from both parties. You'll recall that approximately a year ago, Julie Adams, who currently sits on the Fulton County Election Board, refused to sign certification for one of the elections, stating that certain information was not being made available to her or to the election board. In that case, it also ended up in court, and the court ordered that she sign the certification for the election, regardless of what information might be missing. So again, a previous case with regard to, again, the commission and the election board in Fulton County seems to confirm that, in fact, a court order may indeed compel behavior, compel action on the part of an individual, and that was cited within the hearing just ended as well. We will continue to watch this very carefully. The implications of a commission board being able to avoid appointing certain individuals is important, because this same dynamic exists across much of Georgia and could have a bearing on other election board appointments both this year and into the future. One of the things that the defense attorney cited was, well, we should have the ability to get to the appeals court, and we'll do it expeditiously, or we'll have the ability to go and have legislative change, but we can't do that today. The challenge, though, is that the previous court order compelled them to act, the commissioners to act, and they did not. And now they've been called, their attorney and the action has been called into the hearing held just today. So there'll be more to this. We are assured. The implications for this go well beyond Fulton County, across many counties in Georgia. And we'll be able to continue bringing this to you both from the Georgia Record, georgiarecord.com, and also CDM. We appreciate you being with us today, and we'll see you next time.